When we're talking about starting with the Fair Debt Collection Practice Act, or FDCPA as it'll be referred to through the seminar, the first thing you need to identify is who and how does the statute apply to. In order for the FDCPA to apply, it actually has to be a communication. And this is generally fairly simple. The statute says that the definition of a communication or debt collection communication is the conveyance of information regarding a debt directly or indirectly to any person in any medium. That's pretty simple, but when we talk about how to comply with some of the disclosures, we'll talk about Zortman, a case called Zortman, and also Foti that talks about what a communication is for compliance purposes. So that's not as clear as what it would normally be based on some of the information, some of the case law holdings that have come out. The definition of a debt. Under the Fair Debt Collection Practices Act, a debt has to be a consumer debt in contrast to a business or some type of commercial debt. The definition of a consumer debt under the Fair Debt Collection Practices Act is actually any obligation or an alleged obligation for the consumer to pay money arising out of a transaction in which the money, property, insurance, or services are subject to a transaction which are primarily for personal, family, or household purposes, whether or not such as reduced to a judgment. There's a very good distinction as far as a business debt versus a consumer debt generally is as if it is personal, family, or household reasons. And sometimes the debt can be discerned very easily whether or not that meets the definition. For example, medical debt, homeowners association assessments, generally retail cards are usually for personal reasons. Sometimes it's easy to define that. There are some instances in which are not generally accessible as far as determining whether a commercial or consumer debt. It could be a credit card that's used for business expenses. If the nature of the debt or the transactions are for business-related items, such as travel expenses for business in some ways, even though that card may be taken out personally, it may not necessarily qualify for a debt under the FDCPA. Also, what is exempted from the FDCPA for debt is some types of transactions that are not voluntary, such as taxes, fines, penalties of such, are not consumer debts under the FDCPA. So it's very important, if you're defending these claims or if you're collecting these claims, to know the characterization of the debt that provided. Sometimes they're very simple. If it is a business-to-business transaction, very easily to define that it is a commercial or a business debt that exempt from the FDCPA. And the reason for that is that Congress decided that this statute was necessary to protect, as we'll talk about later, the least sophisticated consumer. They felt that consumers that were buying purchases that were of a consumer nature or a personal nature needed these protections under the Fair Debt Collection Practices Act, in contrast to businesses using business transactions that did not need the level of sophistication or protection regarding the types of collection activities that would go towards business-related items. So it's very important to discern if you're doing collections or if you're defending a claim under the Fair Debt Collection Practices Act to determine, first of all, whether or not the debt actually applies. It's critically important. There are times in my experience in which I would get a credit card, an action under the Fair Debt Collection Practices Act, a lawsuit that a collector may have been bringing. It's a credit card related bill. It's not necessarily related to a financial transaction that was of personal nature. I recently had a case in which a loan, a mortgage or second equity loan that was taken out was really for a rental property that was used for business rather than personal. So you generally just cannot assume, unless it's a medical bill or something that's obviously for personal or family use, that it is a consumer debt under the statute. So if you're defending these claims, please be wary when you're looking at these that not to waive the nature of the consumer debt unless you solely know that this was for personal, family, or household uses. Other definition that's important is that you have to be a debt collector. And the statute itself in the definitions talks about those entities that are exempt as a debt collector or exempt from the FDCPA liability. Creditors collecting their own debts are not debt collectors under the statute. So therefore, JCPenney's that's collecting their own retail cards is not subject to the Fair Debt Collection Practices Act because they're a first-party debt collector. However, if JCPenney's hires ABC Collection Agency to collect the debt, they could be deemed a third-party debt collector under the statute. One of the key points and one of the exemptions under the statute is that a debt collector has to be collecting a debt on behalf of someone else, and the debt has to be in default. That debt has to be charged off in some way in which the original creditor has defined that the debt is subject to collections and is no longer a valid or existing debt for charge-off purposes. And usually, the way the statute is usually defined is that the debt has to be charged off, and it's usually defined by the original creditor. So if you are engaging in debt collection and you're working through an original creditor, say it's a medical debt office or another account, or maybe even a student loan, if you're making those types of collections, you need to establish the relationship. Has the original creditor, has your client deemed the debt in default? That's very important as a creditor and also as the debt collector as to whether or not you need to comply with the Fair Debt Collection Practices Act, because you want to make sure if the debt is being charged off and you are legally defined as a debt collector under the statute, you need to provide the appropriate disclosures that are required under the FDCPA. If you're not, you may be sued under a state law for mischaracterizing the nature of the debt. If the debt hasn't been deemed in default and you're sending out letters that it's in collections and everything else, state law may apply and saying, well, you're misleading the characterization of the debt, you're providing false information to a consumer as to the level or the legal status of the debt if you are saying that the debt is subject to collections when it's actually has not been charged off and is really a billing issue. So it's critically important. This is another practice point when you're talking about defending a collection agency or collecting a particular debt. I've had at least a couple cases in which the debt has not been charged off, and we have won summary judgment on areas in which the debt collector didn't meet the definition, so the FDCPA didn't define, and the evidence on summary judgment was the original creditor coming forward saying, no, this medical bill was not charged off, and therefore the debt collector was not responsible for complying with the Fair Debt Collection Practices Act because they were not considered a debt collector under the